Hello? 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 Are you there? Hello? Hello? I get it. No, I got asleep. Hello? Okay. Hello? Anyone there?
And how are you guys today? Well, I'll see if I can change that. No, I'm kidding. Just time to show up. No, I'm kidding. Hello, Miss Lacey. Okay. Arbor Meadows versus, is it Fujimaki?
They're down the hall, Your Honor.
Who's down the, what are you talking about?
Fujimaki's down the hall. With attorneys. I don't know how to,
Oh, there's an attorney on it?
I think so. I got an email this afternoon that they filed an answer, complaint, a jury demand's too late, so I'm gonna object.
Oh,
But these individuals are cops.
yeah, no, I you know what, Lacey?
Just trying to help you move your docket along here.
You have delayed everything. I would have been done by now, but by the time I listened to your explanation. So Mr. Stringer is down the hallway.
I believe so, yeah.
Got it. Okay, so I'll pass that. And then Arbor Meadows versus Rachel Cox.
April Lacey for Arbor Meadows, Your Honor.
Your name?
Rachel Cox.
All right. And where are we on this case?
Thank you, Your Honor. This is the termination of Tennessee based on the fact that the tenant's dog was allowed to run loose and attacked or bit another resident and their dog. So that's what this termination is based on. The tenant has admitted that the dog was allowed to be loose. Guidelines require that the dogs be on a leash.
I think the last time that you were here, you said somebody, a neighborhood kid or something, let it off, right? Okay. Well, where was the dog where the individual had an opportunity to do that?
She was in my yard.
Leashed in your yard. And then somebody came up, you're saying, and let it off the leash.
Correct.
So I guess the other thing is that the biting incident, where did that occur?
It happened in Arbor Meadows. And since
No, I got that, but it wasn't in your yard.
correct, it was in another neighbor's yard.
So, Your Honor,
Yes, go ahead.
one of the rules in the community is you're not allowed to have your dog on a tie down. You have to be out there with your dog under control on a leash. Had that been the situation, then of course, this individual that took it off the lead probably would not have been able to do so without her knowledge.
Yes, and I had this issue with, I think it was Arbor Meadows, where the dog was on a tie down, and that's why I was trying to figure out where the dog was. So, ma'am, what's your position on this?
So since the last court date, I was advised by legal aid. They're not taking any landlord and tenant cases right now, but they advised me to rehome her. And so I did.
Your dog?
Mm-hmm.
Okay.
And I'm asking a motion to dismiss.
Okay. So I'm not sure that a dismissal motion would be proper. So you've rehomed the dog. The dog is someplace else.
Correct.
Okay. So typically, just so that everyone would be aware of how we've handled these cases. I'm not sure what the plaintiff's position is, but before I ask, is that if you've done that, because that's what I was going to suggest that you do, if the circumstances were as I thought they were, then the question would be that there would then be a probationary agreement or an agreement that would be entered into that you would not have dogs there for, I think the last one that we had, I think it was for a year.
That's fine.
And then with that, and you could probably both have both sides of it, where there then could be a conditional dismissal with that proviso along those lines.
Okay.
But I don't know, Miss Lacy, is your...
I did just clear that with the property manager. She is willing to enter into a consent judgment where she agrees to not have a dog for at least 365 days, not allow a dog to visit, not sit for a dog or have a dog on her property for 365 days. And of course, continue to follow the community rules and regulations.
Okay.
Costs within 10 days.
All right. And that's basically what it would be. The only issue is, are you indicating you want a consent judgment as opposed to a conditional order of dismissal?
We'll do conditional dismissal.
Okay. You understand what that means, ma'am?
Yes, I do.
Okay, so the case would be dismissed conditionally as long as you follow those guidelines. If not, you said no dog for a year, right? And then dogs aren't allowed to visit, that you won't have dogs on your possession or in your possession on your premises or anywhere else in Arbor Meadows, and follow all of the other rules and regulations. Then the case would remain permanently dismissed. If it's not, if something like that happens or is alleged to have happened, then upon the filing of an affidavit, and I think there'd have to be a notice period. I don't think we could do it without that. You would get notice of that claim. Let's say somebody comes along and says you had a dog, and you would be entitled. I wouldn't do it without her having the right to have a hearing.
Okay. 4A then.
Right. If somebody is alleging that occurs. So you would be entitled to a hearing before any action would be taken on that, where there be a judgment or an order of eviction.
Okay.
That makes sense to you?
Yes, it does.
Okay. You have any questions regarding any of that?
No, I don't.
All right. Would you give Ms. Lacy, when she drafts it up, and I will be reviewing it myself for the terms of that, do you have a problem with her signing your name to that document for entry?
Not at all.
Okay, very good. So that she has your permission to do that. I will do this, that once it gets to me, I'll advise you of your 3-day right of rescission. After I sign it, you have 3 business days to think about that. If you believe that there's some legal reason, some confusion on your part, some right you didn't assert, or some other misunderstanding, you'd have to file a motion. You have those 3 business days to file a motion to set this aside. You understand that?
Yes.
Doesn't mean that I will, but you have that time to sort of think about it and do whatever.
Okay.
Okay? All right. Thank you guys for working it out. How long
Thank
had you had the dog?
We had her almost 3 years.
Yeah, and it's hard. I know. When you appeared the last time, I was thinking, as I listened to what you were saying, I said, I'll be honest with you, I'm glad you made the decision that you made, because I hate having that conversation with people that this is what you need to do to have your house. So I'm glad it worked out this way.
Okay.
And it's a she,
Yes.
good home.
Yes.
By the way, when I saw the picture of the dog, beautiful dog.
Thank you.
I know, just what kind of,
She was a husky.
all husky?
Mm-hmm.
Oh, nothing.
Got a lot of energy.
What do you say?
They have a lot of energy.
Well, they have a lot of energy, but the one thing I have myself, yeah, oh, she is. I didn't get it good enough. That's a definite husky. I have a half husky, half Australian cattle.
Oh, wow.
And the one thing is, did she talk to you all the time? Did she? Yeah, that's the one thing about huskies you have to get used to. They just want to talk.
Yeah, she does. She'll let you know too.
Yes, exactly. And that's this one that I have. The other dogs are all kind of quiet, don't say anything. She's always got something to say. She's just, but she's good.
Well, thank you.
Thank you for working it out.
Absolutely.
You take care. Have a great weekend. Court calls the case of Arbor Meadow, right? Versus Akio Hajimaki.
Gabriel Lacy for Arbor Meadows.
Thomas Stringer, appearing on behalf of Kyo Fujimaki, who was present.
All right. Okay, what's the issue in this case?
So there are two outstanding issues in this case. We're asking for the defendant to trim his weeds that are along his lot line, and also remove a damaged vehicle from his driveway.
So those are the two issues?
Those are the two issues.
Well, we understood there to be more issues,
He's
but
corrected everything else.
Okay, so there were more. He's corrected them. These are the only two that are left.
Yes.
all right. The trimming weeds, I suspect, can easily be resolved if there really are some trimming weeds that need to be done. The removed vehicle is not part of any pleadings. As far as I can, it's not, it is operable. He drove it yesterday to my office, has a license. He has two vehicles. So we can present evidence.
There. Okay. So from the landlord's perspective, what was wrong with the vehicle?
The vehicle at one point did not have registration tag. It does have registration.
What was the last thing you said? I'm sorry.
It does have registration.
So it's got registration tags, it's insured, it's drivable.
Yes.
So that seems to me to be an issue that is also now being corrected. Maybe.
So they wanted a conditional dismissal. I got it. He's just wanted to demonstrate that his cars are registered and very much valid.
These are the two issues. I was going to let Brother Counsel look at them before I had them passed.
So these are the two issues, was the car and the weeds.
Yeah.
Okay.
Let me confirm. You talk about these?
Yes, that's it. Got a covered car in the picture.
Pardon?
He has a covered car in the picture. We don't have a problem with that one.
But that was, the covered one wasn't the one you were
No,
talking
it's
about.
not.
Gotcha.
It's the damaged vehicle.
Vehicle.
Next bombs.
Yes, the it's not going to exist now. It's dead.
I guess this weed line is something that has been flowers.
Yes, the
Okay. So I'm not sure what you're saying.
Ly Ly Li Ly D.
Lily?
Lilies.
So he's got to weed it then, Your Honor, because all we see are weeds, no lilies. And of course, this isn't the time of year for lilies, but
One man's weed is another man's flower. No, but
unfortunately, in Arbor Meadows, you're not allowed to have,
No, I didn't plant. Sorry,
No, it's okay. You didn't plant it?
I didn't.
These have always been there.
Comes up every year.
Right.
Oh, so can I see him? It's some type of perennial that just comes back or no?
Yes.
Okay, the management, she's shaking her head no,
Oh,
and I don't.
I don't know. Must be gay.
Yes.
Are you talking the grass stuff?
Yes. This
Oh, those aren't lilies.
trend.
No, they're not, at least don't appear to be lilies at this
No,
point. Yeah.
well, I mean, I'm no expert, but I bet you these aren't lilies. But right, this comes up every year because it's basically grass, weed. So, what's your client's position on this? Other than on the back of a tractor mowing it down? No, I'm sorry. Go ahead.
Flower I did not plant, and I can take them off every fall.
Every fall. Okay.
Yes, it's a.
All right. So are you willing to take them down now?
It's just I'm taking care of. I understand that's not mine. Because the land is not my property, and I can take care of.
Well,
It is his lot line, Your Honor.
okay, that's what I was going to ask. I mean, it's got to be your lot line only if the covered vehicle is properly parked, your lot line has to extend over a certain number of feet. So I would be shocked if this were the neighbor's lot.
All right. So you're willing to take it down? All those weeds, your lilies, you'll cut all that.
That's right. The flowers comes up every year, and it dies every before winter, and like
So let me ask this, and maybe the management knows, because they probably see it all the time, because with this picture, are there flowers that come up before the overgrowth comes up, or?
If there is, they don't show.
Gotcha.
A closer.
Right, but
Well,
if what I'm hearing from him correctly is that somewhere in the midst of this, there are flowers,
correct.
and that those kind of just grow there, and then in the fall, as it goes toward fall, this is what it begins to look like.
Is that correct? Flowers grow in that area. In the fall, this is what it looks like. The weeds come up, flowers don't. Any longer, correct? Okay.
Okay. So that's what I'm hearing. What do you?
So it's like this all year long. The flowers, there may be a couple flowers that may pop out, but it's weeds that need to be cut. And if he wants to plant flowers,
Right. So if he wanted a flower bed there,
Yeah.
he could have a flower bed. But I think
then you have to weed.
yeah, these are weeds. So what I don't want to get into, and we may be getting into it without it being said out loud, is a problem that they had in Ann Arbor and part of Pittsfield where the natural flowers or native flowers that a lot of people would call weeds became flowers for people's lawn extensions. I think the community rules, at least the last time I looked at them, I mean, kind of prohibit that notion from occurring.
Well,
That's what I was gonna say, Your Honor. Unfortunately, because he does live in the private community, the manufactured home community does have rules regarding even the type of flower bed you could have. If you were gonna have a flower bed or a raised garden, you still have to get permission from the park. Approval.
Okay.
I guess I'll just say this, is that as far as I know, this line of weeds, flowers has been there a long time. I don't think he's been brought, go ahead. You have something better to say than I do?
Yes. Do you have a picture?
Oh, that picture?
No, another one.
Yeah.
Yes.
Get closer.
Yes. In this picture, it is black and white. So it's a little bit harder to distinguish which one is weed, which one is flower, which one is grass lawn. The last time, the big tree is removed here from here. And after tree removal is done by Aba Meadows. And then Aba Meadows told me they will put grass seed, but they didn't. It's this is the remaining ground is just bare ground.
Got it.
Because that is just natural ground. Yeah, weeds comes up. I tried to cut by lawnmower, but the ground is not flat, and the weeds tend to grow up faster than lawn. So I thought that weed means those weeds from those area because it's more visible than others.
But if they had put grass there, you'd have to cut the grass.
Of course.
Right. Okay. So, I mean, this is actually really simple. That's got to be taken down. It's got to be mowed over.
Yes,
All
I believe I'm taking care of lawn cutting very well.
Okay.
Never
And so that part has to be put in there. So that's got to be taken down.
Right. The last time, that is 5 years ago, Aba Meadows complained about lawn cutting just $50 and filed to the court. But since then, I always cut the lawn,
Got it.
the appropriate timing, and I believe I never failed.
So, and Mr. Stringer, you had mentioned they wanted a conditional order dismissal regarding it, or what did they?
Well, that's what they're asking for, but I mean, he's agreeing to cut the grass down. The vehicle is legal. So what would we need a conditional dismissal for? Granted, based upon the allegations that were made in the complaint, we filed a answer and an
Yes.
amended answer and asked for a jury because he didn't want to waive his rights. But I recognize this is probably not a jury case at this point. So
I am so glad. And you know what? There are attorneys with much less experience than you that would have been coming in wanting a jury. And
no,
yeah, no,
he just didn't want to waive his rights. So
right, I understand.
I agreed to at least do it up.
So what would be the necessity or the need for a conditional order dismissal?
Make sure that the grass and weeds get cut down. And if it's counsel can't testify, but counsel is stating that this is the vehicle he drove to your office?
Well, that's what I've been told.
So you don't know?
I didn't go out there. He told me he drove that vehicle to my office. He could, if you wanted him to swear to it, I guess he could.
But that,
If it's an inoperable vehicle, it is not allowed to be on the property.
right, but you're gonna have to define inoperable,
Not
Be-
drivable, as in.
but that's drivable.
Not according.
Well, I don't know if it's legal, but it looks drivable to me. You know what I mean? I mean, there's a difference between, do you have all the necessary equipment to drive it as opposed to like a headlight?
So he signed a document saying, please be informed my vehicle, the Nissan, is legally licensed and operable. I mean, he's willing to even testify to that or swear to it that this is. I mean, so it doesn't appear to be in violation, assuming those two factors are true.
Mr. Lacy, how would you, I mean, I guess we'd have to agree, first of all, upon a definition of operable
I mean,
as opposed.
legally operable, I guess, would be the definition we'd be looking for. Because if he were to take this vehicle out and drive it at night.
Right, but if you drove it during the day, there's not gonna be an issue.
I think
Presumably.
it's supposed to have a front bumper. Taking me back to my Defender days with,
I looked at this, I'm like, there's no bumper on it?
no, there's no front bumper.
Well, you just don't hit anything.
Well, he's prepared to say he drove it to my office yesterday.
You drove that vehicle to Mr. Stringer's office yesterday?
Yes. Yes. The problem is, how to say that? Bumper was broken. It's minor broken. It couldn't, so I removed the bumper because it's not too well attached. There is a problem of headlight glass. Headlight itself is still working. And what I need a car is just grocery shopping every other day or something at the daytime. So this is, by the way, frame is okay, steering is okay, wheel, tire, everything okay, and engine is okay, of course. It's just headlamp glass was broken. Headlamp itself still works, and bumper is intentionally removed because it's well attached. I'm going to fix those because it's still operable.
Okay, so how long will it take you to fix that car and get those weeds down?
Means time?
Yeah, how long?
How long?
I don't know. Because I don't want to bring to the dealer because they will use new part which costs so much. So I have to go to junkyard to get the same one. Can I find the same parts within 1 month? I can't promise, but it's drivable anyway.
Can you mow the lawn in the next week?
Hmm?
Can you mow the lawn in the next week?
Yeah, I'm doing.
You can mow those weeds in the next week.
Yes.
The weeds can be mowed the next week.
And
Your Honor, we're willing to enter a conditional dismissal where the resident cuts the grass, weeds, flowers, whatever is along that property line, within the week, and, agrees to not, keep any inoperable vehicles in his driveway. So we will concede that the vehicle, while it may look like it's not operable, according to his testimony, it is operable. But if it does become inoperable.
So what's Lacey got against hoopties? No. I'm sorry.
I mean, the case would go away and we would dismiss it and that would work.
Well, yeah, so here's what I think. What's this month? This is, okay, so what I might suggest is a conditional dismissal for a period of 7 months with those terms, not a whole year.
Okay.
But just to, really what would be almost the first cutting of something that he's going to maintain that and then call it a day.
Well, I guess the question is, if he goes and mows it right now, let's say he gets it done in the next week, so that issue is resolved.
The issue isn't how quickly it can be resolved. The issue is the fact that we had to come here with the issue.
Yeah, I mean, and that's why I was suggesting that period of time, because what I'm thinking of is get it taken down now, then through the spring, just make sure that he's maintaining it. I mean, I don't think every year he'd be coming in trying to deal with it, but if you get the first cut and then the cuts after that, I'm easier. I think it's the problem is going to be is that if he doesn't cut it in the first place, then it becomes much more difficult as the season goes on. So that's why I was suggesting that. But I mean, I appreciate both points, but
I agree to the 7-month term. I think that's.
Do you agree?
I want to speak something.
Okay.
I want to separate a vehicle repairing and lawn or
Weed.
ground thing, because grass is growing and weed is sometimes growing. So I always maintain grass cutting always. My question is how I can prove next 7 months.
you don't have to prove it. You will just, the only thing that has to be shown to the landlord is that you get it cut down now. And then when it starts to grow back in the spring, that you maintain it. But you don't have to prove that. They would have to prove that you're not doing it.
Right. So I don't think that is a new condition. It's just the same as before, same as now.
And that's the problem, Your Honor, that we have to come here because he allows it to get out of hand for so long. And now he's like, well, I can cut it. And I don't know why I have to be here or get a conditional dismissal because I can cut it and it's gone. But the fact that we had to file the case to address the issue after we've sent him notice after notice is the reason why we need the conditional dismissal with the terms. If he had come to this realization before, we had to file the case.
Folks, I've listened to everything. There's not really particularly an issue for me to try. What I'm going to do is I'm going to just order a conditional order of dismissal for a period that goes through May, if I counted my month right, May 31st. That he will not keep inoperable vehicles and will maintain the lawn area.
Thank you.
I'm just going to order it. If plaintiff believes that there's a violation, then it would be a 4A where there would have to be a hearing. so that they can't just file a judgment and do that. Okay?
Understand?
So,
So this will be dismissed as of May 31st.
Well, it'd be permanently dismissed as of May 31st. It actually is conditionally dismissed the moment I sign the order of conditional
So
dismissal.
it's conditionally dismissed now, but you have these terms and conditions. You have maintain operable vehicles on your property, and you have to cut the yard in that area where the weeds are.
Okay? All right. So I'll look forward to the paperwork, and I'll just mark this file as conditionally dismissed along those terms. You guys can work it out.
Thank you, Your Honor.
So when are we supposed to be here for the jury, Your Honor?
Yeah. 2028.
Good seeing you again, Your Honor.
Good seeing you, Mr. Stringer. Always a pleasure, sir. Is it Gunan versus Holly Ellison?
Clara Ganon.
Good night.
Good afternoon, Your Honor. I'd like to start. Requested to appear under Michigan Court Rule 8.120 on behalf of Ms. Ellison under the tutelage of Attorney David Santacroce.
I hate when those Michigans, they use those big words. What's tutelage?
Oh,
I don't know. They do that just to irritate.
I don't even know what it means.
You've been before me before, right, young man, or no?
Yes, that's correct, Your Honor.
Yeah, I thought so. But you didn't use tutelage the first time.
I guess not. I just
No, you didn't. You didn't, because I would have called you out on it at that point. Anyway, all right. Where are we in regard to this case?
So we're very close to having a conditional order dismissal. I think we do have it, actually. We drafted it and sent it over to Ms. Gannon, and I think we had a couple of little tweaks this morning that we did, but I think we're ready to sign it. So I think we should have it to the court next week, I would say, for sure, unless Ms. Gannon says otherwise.
I agree.
You agree?
Yes.
Okay. You
And
know,
so
it's like, how long does it take a University of Michigan student to tell me I just need an adjournment? Go ahead.
Right. So we requested adjournment. 2 weeks is probably best, although I'm actually going to stop talking, man. I think you're going to.
Yeah, you should have done that a while ago. But will the 14th work? Can you get everything into me by next week?
I think so.
What are you looking at when you say that? You're a student. You have no schedule.
He's got quite a busy schedule, Your Honor. The
Oh,
thing is,
okay. Yes,
the
so
thing
they
is,
say.
if we don't get it in by Wednesday, close the business, then we're back here Friday, correct?
Well, if both parties agree you're going to do this, right?
Oh,
Yes.
I mean, so I can do it one of two ways. I can put it out till next week so it has a date, or I can just mark the file conditionally dismissed and wait for and just say order within 14 days.
Quite honestly, it doesn't matter to me. If Miss Gannon has a preference,
Both options are okay with me.
yeah, I think we'd rather do the latter.
Oh,
Your
great.
Honor.
Nobody can make a decision. So this is what I do.
I can.
Conditionally dismiss, order 14 days.
all right, perfect. Thank you, Your
Thank
Honor.
you, Your Honor.
All
Thank
right,
you.
Ms. Gannon, thank you. Wow, that took way too long. People. Court does call the case of David Pata versus Seth Martin.
Good afternoon, Your Honor. Paul Fessler on behalf of plaintiff, Dave Pata.
Your name?
Seth Martin.
All right. Where are we with reference to this case?
Last time we were here 2 weeks ago, the court ordered that my client be allowed into the premises to attempt to remediate some of the problems that were in there. He has gone in there, and he has gotten estimates on cleanup. Looks like it's going to be $11,000 for the cleanup. Defendant has not removed any of his possessions from the home yet. We're asking for an order of eviction today under section E of the proposed judgment, because the tenant is willfully or negligently is causing a serious and continuing health hazard to exist on the premises, or is causing extensive and continuing injury to the premises, neglecting or refusing either to deliver up possession after demand, or to substantially restore or repair the premises. You recall at the last hearing, Your Honor, he's not living there. He just has all of his possessions in there. We would like an order of eviction so we can start cleaning up the premises. There is mold present in the living room. Everything has to be wiped down. Nothing has to be done in the basement. Nothing has to be done in the garage. Everything can be bagged up and tossed. We just need defendant to get his possessions out of there.
Sir?
So what he's saying is not entirely true. I have been taking loads out almost daily. There's quite a bit of stuff in there that has been damaged due to the neglect and him opening the windows, which he did again since we've last been here. All the windows were left open. It rained again on my couch. There's at least, I haven't even finished going through inventory.
What, is that just today that it rained?
A couple days ago, Your Honor. Within the last 2 weeks since we've been here, I've been going and taking loads out of there with my truck almost daily, if not every other day. I'm going to have a trailer available this weekend on Saturday or Sunday to start taking the bigger furniture. But there's I contracted a fungal infection in my face due to the mold that's in the house. I was sick for over a week on antibiotics for 2 weeks. It's not an easy mess.
Sir, how do they got in there? I'm not clear on why I have to order some of the common sense things to occur. They wanted to make the repairs. They needed to get in. There's a big fight about him getting in to basically be able to look at it to figure out exactly what he needs to do. And now it comes down to they were able to get in, they were able to get an estimate. It's headed along that direction. You're not really living in the premises. And now it's a matter of getting your stuff out, and all I'm hearing are excuses.
Your Honor, he's never been blocked from access to the house. He's always had a key and a garage door opener.
When are you moving your stuff out? Let's just get to I'm just getting right to it.
Can I have a couple of weeks to get it all out? I've got quite a bit of stuff still to move, and it needs to be cleaned before.
I thought you just said to me that you'd been taking loads out, and then you said you were going to have a trailer this weekend to get the big stuff out. So why is it going to take 2 weeks?
I'm all by myself. I don't have anybody to help me, and I'm low on money from having to move yet again within a year after going through a long court battle of divorce and child custody issues.
When I approach, I have some pictures of just the condition of the house, just so you have an idea of what we're looking at here. Those were taken earlier this week. Defendant has not lived in the premises, and this is what we're looking at.
What do you have to say to these pictures, sir? I mean,
all the pictures except one are the garage. That's stuff that's all packed up and in the tubs. It just or the rest is my tools. Kitchen sink with the dirt dishes. And that way, because there hasn't been hot water in there, so the pipe broke in the basement. There's still no hot water in the residence. There's no furnace operating in the residence. There's no filtered water in the residence. It comes out of the tap. It smells like sulfur and it's like brown water. Nothing has been repaired since the pipe has broken and flooded the basement and ruined all my stuff. The pipe is now leaking yet again in the basement. It's filling up with water on the side.
you're not there. They want to make the repairs. In order to effectuate the repairs, does all of these things have to come out? Is that?
Yeah, we need to do a foundation repair. I can't get through the garage to have a contractor bring in a new furnace, hot water, washer dryer. I mean, you can't even barely walk through.
Sir, if I order an eviction and the removal of these items, you've lost them all. Is that what you want me to do? Then tell me how you're going to get this stuff out so that these repairs can be done. Because at this point, you're causing waste to the premises.
I can have a path to beer to the garage, through the garage for him to get to the basement tonight or tomorrow.
Okay, that's not how this is going to work. Here's what we're going to do. And it may end up, but I'm not prepared to necessarily order the eviction portion of it. But whatever company's the cheapest, get a pod and just put what you, and I'm not saying that you got to get more than one. I'm just going to allow you to stop waste, and I think it's under 4.201H, to not cause continued waste to the premises, because I do believe that in great part because of the tenant, and you want to get in there to repair. Get a pod, put it out there. Those items that look like they are valuable, and I'm not gonna. If you didn't get them out of there, I'm not going to be hearing that this valuable thing was left outside. Yes, sir.
There's a huge compressor. It's 5 feet tall. There's transmissions, engine blocks, cherry pickers
in the garage.
Yeah.
Oh my God.
I mean, it's an unreasonable amount of.
But if you have to move it, I mean, if I order the eviction, then you're going to have to pay somebody to come in and move. That's either way. You're going to have the same issue. I hear you, but I'm just saying, if I were to do as counsel's indicating, give a judgment, order the eviction, you're going to have to get somebody in there to move everything to the curb. You follow me?
Yeah.
So it's going to be an expense and a burden regardless, because you're not getting cooperation. Go ahead.
If he wants the stuff, I mean, can he pay for the pod and move his items into the pod?
Here's going to be the problem. I don't intend that. How do I do this? The initial layout is going to have to be yours because you've got to get in.
Right.
That's what I'm saying. My intent is that he's going to pay for the pod. But if I say you pay for the pod, that's not going to happen. The way he's dealing with this, it's not going to happen. You follow what I'm saying? So, yeah. So what I'm saying is, I'm not ordering you to get more than one. And I'm going to allow you to use discretion. Those things that might be damaged as a result of being out in the elements, go in. Those other things that can withstand that, and just pray the snow doesn't start flying. And you can go outside of it. And sir, so that you understand, you heard what I just ordered, right?
If I may ask if I can have at least the weekend to clear the garage out where we get the situation started?
No, because you should have been doing this before now.
You're right.
I mean, you just come up with these periods in time saying, this is what I'm going to do. This is what I'm going to do. Right now, you're in a circumstance where you have to beat the pod there. If he goes out, leaves this courthouse, calls a pod, and they said we can have it there tomorrow morning or tonight, that pod's there. I'm not delaying this anymore.
Can I say something?
Sure.
He has 3 project cars, a horse trailer, a tractor, turkeys, geese, chickens,
What do you,
lawn furniture.
live ones?
Yeah, They're all outside. There's bumpers and all kind of stuff stacked up along the garage. It's been there for months that he didn't have permission.
Turkeys?
Yeah.
No, I got an idea for those.
Like wild turkeys or like,
Excuse me?
Wild turkeys or-
Yeah. Well, they're domesticated.
coming up on the holidays. That was a bad joke. So what are you suggesting in terms of,
Well, I guess the question is, can we tow the vehicles?
here's the problem. If you tow the vehicles, you're going to be putting them someplace. Somebody's going to have to pay for the storage of the vehicles. It's also going to be a more complicated process than just me saying to tow the vehicles, because it's going to have to, I mean, what you're going to have to deal with in terms of the tow truck drivers, it's going to be a little bit more complicated than to do the work on the premises. All right. Do the vehicles need to be moved out of the way? Okay. And I'm trying to make it so that the repairs can be done. I realize there's going to be, apparently, I wasn't clear on these animals, but there's going to have to be a lot more that's done regarding that. So what I'm trying to do is allow you a circumstance where you can get into the premises, do the work, not cause further waste to the property, and have the property done. Because I'm not ordering the eviction and removal of everything from the premises. All right. So you think you can find a way, if you ordered a pod, that if I put this out a week, that you can have substantial progress and get and start the movement along the lines of getting those repairs done?
Okay. I need 2 weeks, Your Honor. I'm going to be out of town next Friday.
All right. Okay. So, sir, you understand what's happening?
I need to move my stuff quickly to beat the pods there, right?
Well, you're in a race with the pod. I mean, because it's put in the pod. Now, if it's in that pod, I don't want you restricting his access to it. Okay. It's only there just to protect what may be there that in your mind might need to be protected from the elements. You follow what I'm getting at?
Yep.
All right. I'll adjourn this matter out then to November 21st, 2025 time.
3 p.m.
3 p.m. in person.
Thank you.
Thank you. Counsel, you, if you could prepare an order just indicating that the court, pursuant to the court rule and court order, has taken these steps.
I'll email that to the court later today or first thing Monday.
Very good. Thank you. Court does call the case. Fixing housing 401k plan versus Erica Ward.
Good afternoon, Your Honor. Steve Otherly on behalf of Planet Fixing Housing. Okay.
Donna Toth, appearing on behalf of Eric and Aaron Ward, the tenants on the lease.
All right. I'm almost afraid to ask, where are we?
Your Honor, I believe procedurally we're at this would be the first pretrial hearing because the first hearing was adjourned because Ms. Toth was out of town.
Yes.
Well, I didn't sign the order, but it was adjourned. But that's okay. However you want to look at it. Yes, procedurally. Go ahead.
Your Honor, tenants Erica and Aaron Ward own and operate a horse boarding farm on the property. Under the lease, tenants are required to pay base rent of $5,500 per month without any deduction or set off whatsoever, and that's paragraph 3 of the lease. Tenants, what really kickstarted this dispute, tenants set off $2,800 from the June 2025 rent when they unilaterally placed the hot water tank on the property in violation of the lease. Tenants have not paid rent since August of 2025. From my knowledge, tenants are supposedly placing the rent in their attorney-client escrow fund. They're paying contractors and for supplies with the rent money owed to landlord. Tenants are operating their commercial horse farm rent-free on the property during the pendency of their circuit court action. Tenants admit to withholding rent, so there's really no factual dispute here. Under the lease, paragraph 19A-C, the lease allows landlord to terminate and recover possession of property. Right now, I believe the base rent owed is $24,800.
24.8.
Yes, 24,800. Or if you want me to get into the procedural history, because there is a circuit court action that was filed.
Well, I was just going to ask about that. Well, I'll get back to you. Let me just. What about the circuit court action?
Your
Is
Honor,
it between the same parties?
it's between the same parties with an added party, Willow Ward Equestrian, which is the business that operates on the property.
Got it.
That is the horse boarding farm that the tenants own. So in June 13th, on June.
Can I just ask?
Yes, Your Honor.
What is the general subject matter of that circuit court action?
The general subject matter is they filed the complaint and they're alleging that landlord, my clients, didn't make certain repairs on the property, and we dispute, the obligation under the lease agreement. But they're still not paying rent. And under the lease, it says that without any deduction or set off whatsoever. So they brought these claims. It was a race to the court, and tenants filed a circuit court action. And then we were forced to answer and counterclaim for breach of the lease agreement, breach of the guarantee, and we brought a tortious interference claim because tenants have been preventing my client from selling the property. My client's been trying to sell the property, and given their operation on the property, that's been an issue.
Who is that case before?
That case is before. I apologize.
Judge outside.
Judge outside hasn't.
Judge outside.
Okay.
That's correct. Yeah.
All right.
So after landlord filed its answer and counterclaim, we filed a motion to compel payment of rent in August, but the court's earliest scheduling date for that was last week. So we've gone all of this time where tenants are operating on the property rent-free, and my client has his own financial obligations that he's not being paid for, but they're still operating on the property. And just because they filed a circuit court action does not insulate the tenants from defaults under the lease, and also doesn't bar this court from exercising jurisdiction over a summary proceeding.
So, Donna Tope here. You do have hearing that sometimes I'm not able to hear quite well. So I would appreciate that. Your Honor, I know that you are a very thorough judge, and I filed an answer to plaintiff's complaint to recover possession of the property. Thank you very much. And in that answer, I listed out the situation that led to our filing a breach of lease complaint in the circuit court that is being heard by Judge Alzai. In my answer, I stated that the defendants leased the property township Ann Arbor, Michigan. The lease began May 1st, 2021 and ends May 1st, 2028. The property has, and it states so in the lease, has been used as a horse farm. It's zoned agricultural for over 25 years. It has had an indoor arena, showing arena. It's a showing boarding facility. When Fixing Housing purchased the property on a land contract from the former owners, the lease with the wards continued that operation, it operated as a horse farm. So this is a little different than most landlord-tenant cases, Your Honor, because while Aaron and Erica Ward are the tenants, the place needs to be made healthy, safe for the welfare of not only the residents and the people who board their horses there, but also their horses. They have over 35 horses. So those are the beneficiaries of the landlord's duty to keep the premises under safe repair. About a year and a half ago, Erica notified the landlord that several of the outdoor sheds that shelter the horses during snow, sleet, the torrential rains we have 24/7 had deteriorated to the point where they fell down. A windstorm blew several of them down. They were no longer sheltering the horses, and the debris left by the destruction of the shelters was unsafe for the horses in the pasture. Erica Ward notified the landlord, asked for repairs. He did not respond. He also then went into the pastures because he has had it on the market. In the lease, it says that that it's invested, and he wanted to be able to show potential buyers and host events at the property, which he has not done. But he was looking for septic fields, and he had a bulldozer enter every pasture and dig with a bulldozer down 2 or 3 feet to see if the property perked for septic fields for development. It did not. He did not repair those. That is unsafe footing for the 35 horses that have to be out in the pasture 24/7, and they need safe footing. What started this current action, she also asked him to repair several other things. But what started this entire action was about June of 2025, the spigot, which supplies water for the horses, and they need a lot of water, needed repair. It was leaking, and it was going to burst and be unfunctional. She asked him to please make the necessary repairs. He did not make the necessary repairs. Aaron and Erica made the repairs themselves. They also, the hot water heater that provides hot water for the horses to be able to have their poultices for injuries.
But all of this is a result, it was in the circuit court action, right?
Yes, but it's under breach of the lease. And so what started this was that they asked for the hot water heater, which had failed. They asked for the hot water heater to be replaced. It's necessary for the safety of the horses.
But what about the provision that the base rent is going to be paid without deduction?
So that is if they live up to all of his responsibilities.
Is it conditional? That's not what I read.
Well, it is not conditional, but in any contract where one party breaches several.
I have 2 businesses in essence that have entered into a contract. That contract can read various different ways. I mean, you're trying to say that there's a general reading for contract. Maybe if it weren't two businesses operating at arm's length, he might be correct, but that's not what I have.
No, we have a lease, and under Michigan landlord tenant law, which I have researched with the Michigan State University Law School and the University of Michigan, the city of Ann Arbor.
MSU Law School?
Uh,
They
the-
have one?
They,
No, I'm kidding.
they
Go ahead.
absorbed,
It's just my dig at MSU.
okay, well, they do have one, and they give really great advice to their student tenants. And one of them is that if necessary repairs that affect the habitability, the safety, the welfare of the residents who are under that umbrella.
Where is that base rent now?
So in June, they notified him to please repair the hot water heater. He did not. They repaired it themselves. They withheld the cost of the hot water heater. Aaron did the labor installation himself. They paid him the difference between that withheld for necessary repairs that the landlord is duty bound to provide under the lease, and gave it to him. He then,
That's June.
that's June.
Okay, what happened in July and where's that rent?
Yep, they paid it.
August.
We started withholding in August 1st. In July.
So, all right. No, not really.
No.
You
Okay.
ever do that to me again, you'll be out in the hallway.
Thank you. I apologize. I was not trying to.
August, September, October, where is the base rent?
The tenants told the landlord that they were going to have these things repaired, and that they were going to withhold the rent to make the repairs.
Why can't I just get an answer to my question?
And after they notified him, he had threatened to take over the farm, insert his own manager, and they paid the rent into an escrow fund, out of which the necessary repairs were made. They withheld the rent to make the payments to the contractors that were filling the dangerous holes in the pastures.
Where, out of what account?
They paid the account into an escrow fund that I held for them to be able to pay the contractors for the necessary repairs.
Council, like the last case you were here on, now we have a problem. Because either you're going to be a witness or you're going to be a party to this. We ran into this the last time you had a case before me.
Your Honor, I was their attorney, and this was the only way to be able to get the repairs done that had been necessary and posing danger to the horses, the residents.
You're playing, it's one thing if the attorney is using their trust account to hold funds of their client, right?
Yes.
These were not client funds.
Yes. They were the client funds that were to be used to make the repairs for the lease.
Counsel.
In my answer, I have asked that you escrow, the rent was paid with a minor amount withholding that was still a balance due on repairs. The rent was paid this past month, and in my answer, I have asked you to I've asked you to stay the eviction. I've asked you to escrow the rent under the same way you did in our other case. And I've asked you to transfer the case to the circuit court.
Not happening.
Your Honor, their notice for possession and eviction is exactly the counter complaint that they made to Judge Aldzai several months ago.
That's because you filed there.
I understand, but it's the same for judicial efficiency.
Too late.
It's the same circumstances. It's the same claims. It's the
It
same.
may very well be, but that's for the court to decide.
Okay.
And I'm declining to do what you're asking regarding this case at this juncture.
You mean to transfer it?
I want to know where the escrow is.
The escrow is in my, it's all paid out. The escrow funds are all paid out to the contractors. They paid this month's
Counsel,
rent.
do you see the problem here? Do you?
Well, I know you want me to see the problem, but
Then that must be the answer is no.
no.
You took client money in.
I withheld rent.
And then dispersed it.
I withheld rent under the landlord tenant.
But you can't on your own then disperse it.
They dispersed. Erica Ward signed those contracts and paid those contractors.
Toth, if as a tenant, they elect to set up an escrow account to put their rent into, show me the authority that then permits them or their agent to disperse those funds.
This was not.
Show me authority for that. Because I'm going to tell you, you're not going to find it.
My first request was that you stay the possession, repossession.
Denied. Next request.
Motion for you to set up an account for the rent to be escrowed into and paid out.
I am not going to have a problem ordering escrow.
Okay.
What I am going to have a problem with is that I think because of what you just explained to me, that you are a necessary party that has to be joined. Because if they set up their escrow account with you.
No, they paid the rent to me. I did not really, there's no formal escrow account. I held it so she could pay.
Then that's another problem.
Oh my goodness.
Yes, oh my goodness, because the law has to be followed. They can't just give the rent to somebody else. If they're going to properly withhold, and I would have hoped you would have informed them of this, they have to set up an escrow account. Outside of the fact, then, they are really obligated to then let the landlord know where that escrow is.
I did.
And they are. But then they can't disperse it.
How can they pay for the necessary repairs that he did not perform over a year and a half?
File suit and get an order. And the fact that you're a party to that, I think it's going to make you a party to this action, because if that money doesn't appear, I think, I'm not suggesting that it occur, but I think plaintiff has a claim as to you, because you had to take that rent as an attorney, as an agent, whatever. You took that in trust. It's like if they had decided to withhold rent and they went, like most people would if they're going to do this, they go to a bank, they set up the escrow account. the bank can't then, if it's set up as a true escrow account, they have to direct that it's paid out, but that's not what's happening here.
Under landlord-tenant law, tenants are allowed to withhold rent. They don't necessarily have to set up an escrow account. They just have to inform the landlord where the money is, where the money
I
is held.
appreciate you giving me a lesson on
I'm
landlord
not
that I've been doing.
I'm not. I read the Michigan state law about tenants and what to do about landlords who do not make necessary repairs for the health, safety, and welfare of their tenants, which in this case includes horses and boarders. I also did file suit. We filed suit in circuit court for breach of lease, for every single breach of lease that the tenant has performed over the last.
Is there anything else?
No.
Because you're not listening to anything I'm telling you.
I am hearing you.
You're not listening.
I am listening, and I'm giving you an answer when you say you file suit, and I tell you that I did. We did file suit. No. Do you want anything else from me? Do you have a?
I got a ton of questions, but I never get an answer. So you can have a seat. Anything else in the plaintiff?
Your Honor, I would just say that the withholding of the rent is against the lease agreement, and placing in the attorney's escrow and paying contractors and paying for supplies at Lowe's and Home Depot is completely, it's wrong. And what I put in the motion to compel payment of rent is that the case law, we're disputing, and we filed an answer disputing that, we're on the hook for some of these repairs, but longstanding Michigan common law provides that tenants' duty to pay rent is independent of the landlord's alleged covenant to repair in the commercial context. And that's the Reum case from the Michigan Supreme Court, and Detroit Marine Terminals is an unpublished.
Yeah, but statutorily that's been changed. So I understand the common law rule.
In the residential context, Your Honor.
I see what you're saying. Go ahead.
Your Honor, and that's all I have, unless you have any questions for plaintiff.
Is there another hearing set before Judge Outside?
Yes.
What day?
On November 7th?
I believe it's Wednesday, upcoming Wednesday.
This coming Wednesday.
The basis for the termination in this case is really breach of their obligation, in a lot of ways the obligation to pay rent in this case. I think, as I was trying to point out, as this court views it, additional problems and concerns regarding the use of this money. So what I am going to order, which is also unusual to order these cases, but I will order it, that the defendants are to provide to the court an accounting of the escrow paid into whatever the account was and the disbursement. Yes, Ms. Toe.
Your Honor. In my answer to plaintiff's complaint to recover possession of the property and my motions to eviction, motion to transfer case and proposed order proceeding, I explained everything, and I included as the very last page, which was exhibit, I can't read my own writing, B2, and accounting.
Which one was it?
That was defendant's answer to plaintiff's complaint. It was filed on October 24th. They got a copy. The last page of that entire filing is an accounting of expenses paid.
What are the receipts attached?
I don't have, I can get the receipt.
I want the receipts attached. I want a very detailed accounting of what came in,
Yes,
what was paid out.
yes.
I want receipts for all of those transactions.
We have contracts, we have paid receipts. And an explanation of everything that the money went for.
Are you done now?
And the term of the lease under which that expense was made.
Are you now done? Presume yes. So I want that accounting. I am also going to order, how much is the base monthly rent?
$5,500.
Per month.
Per month. This was November paid to you?
The check was sent.
When was the check sent?
The check was paid out of Bank of Ann Arbor's bill payer on the first of the month.
And at this point, you haven't received a check. Give me 55 divided by 4 times 3.
Divided by 4
Times 3, yes. 41.25. I'm going to order that the defendants are deposed with the court within 7 days. Escrow for November prorated in the amount of $4,125, and then are deposed with the court $5,500 on the first of each month, and that rent ordinarily would be due. How long will it take you to get that detailed accounting to me, Ms. Tope?
I'll have it to you tomorrow, Monday.
You've got a hearing before Judge Outside next week.
Wednesday.
So I will then adjourn these proceedings. See where that has got to November 21st.
Is that before Thanksgiving? No,
It is.
it is. Is it the Wednesday before Thanksgiving?
Thanksgiving is on the 27th.
Your Honor, I am scheduled to be out of town with my family and relative in Portland, Oregon,
What days?
from the 20th to December 3rd.
Then fine. Then fine. We'll see you next Friday.
Next Friday?
Yep, the 14th. At what time? 2 p.m. in person. All right, by that time, the escrow, at least the first payment of the escrow should have been paid, or some verification of the receipt, and then we will go from there. Thank you.
Thank you, Your Honor.
Thank you. Thank you.
Clark Road Family Dividend Housing versus Washington.
Hey, please, the Honorable Court, Steve Gant, P 7H219 for the plaintiff, and unfortunately, none of my cases involve chickens, horses, or turkeys.
I'd like any of, or turtles?
Or turkeys.
You just threw that in there as a Spartan, didn't you? You're just, no, he was just trying to get back because of my dig about you. Michigan state law. That's all right. Go ahead.
Actually, I think that's a dig on Michigan law, which I truly enjoyed.
Yeah. All right. And Ms. Washington, are you here? Come on up. State your name.
Naja Washington.
All right. And where are we on this case?
At this time, last time we were here, she indicated she was going to be vacating by October 31st. I talked to my client before the hearing today, and she did put 17 bags of trash in the hallway yesterday. There's been no payments, and she's still not out of the unit. There's currently due and owing $5,065 in rent, $239.40 in court fees for a total of $5,904.40.
590. Give me that number again. I'm sorry.
I'm sorry. The rent 5065, the court fees 239.40 for a total of 5904.40.
All right.
I emailed Sheena to see if I can get an extension to be out by Wednesday of this week. I was supposed to hire a moving company and I still don't have a job. So I had to have family and some other people help me get stuff out of the unit. The stuff that's left there, I didn't have help to have anyone take that out of the unit. So pretty much everything that's there is to be discarded, which is what I emailed Sheena about. Like I said, I still don't have a job and I've been trying to have people help me get stuff out of the unit and trash, but I would have to be put on some type of payment plan or something.
Well, you can work out a payment plan with them, but you indicated certain things to the court as to what you were going to do. That hasn't come to pass. You're not disputing the amounts that are owed.
No, sir.
So what I'm going to do is I'm going to grant a judgment to the plaintiff for possession, finding no tribal issue after hearing for the total amount of $5,904.40. That will be a possessory judgment as well as a money judgment with a writ to issue in 10 days.
Thank you. I will submit that to the court.
All right. Thank you, ma'am. Court calls the case of Clark Road Family Dividend Housing versus China McGraw.
Hello.
Please down in court. Steve Gant for the plaintiff.
Hello.
What's your name?
My name is Shinar McGraw.
Shinar. Okay. And where are we on her case?
Last time we were here, she said she's going to make her payment in full with her next paycheck. My client did receive $400 on November 4th. That leaves a balance of $1,121 in rent, $239.40 in court fees for a total of $1,360.40. That's $1,360.40.
Can you hear me?
Yeah, I can hear you now.
Okay, I'm sorry.
Why didn't you get it all
I didn't know if you
paid?
asked me a question or not.
Why didn't you get it all paid, ma'am?
Okay, so because I am single mother, I thought that I did work up more hours than I thought I did, but I didn't. I did have to pay my babysitter too. I don't receive child support or anything, so I'm just trying to do the best I can.
Okay. Well, this is going to have to get paid, and you're not disputing what's owed. It's just you got to get it paid.
Yes.
So
I'm
gonna go ahead.
I was gonna say my lease is up November 30th, so I do actually plan to have it fully paid. Probably because I get paid again this upcoming Friday, this upcoming next Friday, and so I do plan to pay at least like 700 of it. My parents did say that they would help me pay the rest, so I can try to get that paid by next Friday.
Okay. I'm going to suggest you do that, but what I'm going to do is I'm going to find no tribal issue after a hearing. I'm going to grant judgment for possession in the total amount of the $1,360.40.
Okay.
That's inclusive of costs. And you'll have 10 days to get that paid.
10 days. Okay. Got you. Thank you so much.
All right. Thank you. Have a good weekend.
Bye.
Versus
Thank you, Your
Aisha
Honor.
Frederick. Thank you.
May it please the Honor Court, Steve Gann, P78219 for the plaintiff.
Hello, Ms. Frederick. Okay. There was a conditional order of dismissal. I thought that was supposed to be filed. Well, that's what we had a while back.
Your Honor, I'm here. I don't know if you guys can hear
Yes,
me.
ma'am. This is your motion, I think, to stay the writ.
Yes, I paid it in full.
Yeah, if I may, we've looked at the
Yes.
court account and it looks like she did pay $4,376 in escrow to the court.
She did. And how much is owing?
Currently we've got a balance owing of $4,877.80.
So she's about 500 off.
That is correct, Your Honor. Frankly, I would not object to having the money released to my client, setting this out till the end of November, see if she can get that paid.
Okay.
And
Ms. Frederick, you think you can get that?
How much is left? Because I thought that I paid what
I
was.
think it's almost 500 even. What was your balance amount?
4,877. So 500
Yeah, and I have
20
four.
cents.
It's 501. You just wanted to say that so you could say I was wrong. Didn't you? No, you just wanted to say that. You're on Gann's side. I know what you're doing.
Judge Simpson is
All right.
never wrong unless it's about the Terrapins versus Spartans.
Wow. He is just. Anyway. Ma'am, how soon can you get the 501 paid?
I can get it paid by next week.
You think you could do that?
By next Friday. Yes.
By next Friday?
Yes.
Okay, so here's what I'm gonna do then. I'm gonna adjourn this out 2 weeks, okay? I'm gonna adjourn it to the 21st, 2025 at 3 p.m.
Yeah, I
ahead, Mr.
apologize.
Gann.
I have a jury trial scheduled that day in Grand Haven.
Okay, well, then we'll go to next week. I'll do the 14th. All right?
Thank you, Your Honor.
At what time? 2 p.m. At 2 p.m. Get the 501 paid. I'm going to release the amount that you put into escrow to the plaintiff. Pay the 501 directly to them.
I believe the 501 is for this month's rent.
Right. But I'm looking at just trying to get you caught up so that, because theoretically, I don't have to stay this. But you showed good faith in putting these funds in. You're 501 short. You paid everything except this month. That's all that happened, really, right?
Yeah.
So get that in, and then that way we can get rid of it, and then everybody can breathe a little easier.
Okay, got it. Thank you.
Okay, you follow me?
If I
Yes.
may, as I look at my calendar, jury selection is on the 14th. Jury trial is on the 21st in Grand Haven. I would not object to having this go to the 28th. That gives her more time to get it paid and still within the same month.
That'd be fine, but it's only going to be the two of you here because that's the day after Thanksgiving and I'm not coming in.
Understood. Then the month of December is fine, Your Honor.
The what? The December date?
December date would be fine. She's made a great payment towards it. I also encourage her to work with the landlord. There may be a subsidy issue you can work the landlord on. So talk to her.
So apparently this is what we're doing now, Ms. Frederick. We're going to adjourn it to December 5th, 2025 at 3 p.m. All right. And what I'm going to, the only thing I'm going to require is that you get everything paid through November. I'm not going to worry about December, even though the date's in December.
Got it. All right.
Got it?
Yes.
Okay. And then that way you'll be all set. Okay?
Okay. Thank you.
And I'll release the funds to the plaintiff.
Do you need an order for that, Your Honor, or are you going to do it yourself?
No, that's fine. We'll We'll take care of it.
Thank you, sir.
All right. Thank you, ma'am. Have a good weekend. Blackstone Apartments versus Christine
you.
Fairley.
May it please the Honorable Court, Steve Gann, P78219 for the plaintiff.
Hello.
Hi,
What's your name?
Christina Fairley.
All right. And where are we on her case?
You're at this point, the current balance due is for rent, 7,549.34. I'm sorry, 54.54. 252 in court fees for a total of 7801.54. She did try to make a payment, but apparently the check from Huntington Bank that she uses is so small it cannot go through a check scanner. So my client has made given them ideas on how to make a different form of payment. But the check she gets from a bank, that was only for $1,000. When we were here last week, she said she was going to seek DHS and Hawk, and we've not heard anything from that.
I did email the landlord about me being denied for SARE through DHS.
You got denied with that.
Yeah, and
okay, that's fine. Go ahead.
But I don't know what to do about those checks that he's speaking of. Maybe they could deposit them.
They're too small to go through a scanner.
There's a check scanner they use for their mercantile bank deposits, Your Honor. There's not a location around here, so
the checks are ready to go. I'm sorry, I interrupted you. I'm sorry.
So no, it's okay. But you guys have the checks?
I believe the manager gave the check back to the resident. It's not able to go through the scanner, so they cannot deposit them.
I think he's speaking of he's not talking about the most recent check. I think he's speaking about the check that I tried to issue out. That was 700, but I think I got the number wrong, their account number, which I tried to ask for so I could issue it from my bank to their bank account.
To their bank, go direct.
Yeah.
Do sort of an ACH. But
yeah, but they wouldn't give out that information. And I understand that, so I just
I understand, but if I write you a check and you're not going to take it because it's too small, quit asking me for money.
And I could take it back. I could use it.
Did you? No. So did you get the checks back?
I didn't get the most recent one that I sent out from my bank account.
What about the $1,000 one?
That's the one that I'm speaking about. The one that the last time we were here, well, it was a Zoom call, and I said that I would pay $2,400.
Right.
And the $1,000 that I had.
So did you pay the 14?
I did.
Did they take that?
I don't know if the landlord didn't reach out to me, nor the managers there. They didn't reach out to me and let me know that something was wrong with the current check that I had sent from last week.
Your Honor, I can confirm we have a $1,400 payment deposited into her account on October 29th.
Okay, so that one went in.
Okay.
Then.
So
that form of payment, perfect.
And then there's the $1,000 that.
I'm sorry, I'm getting so confused.
No, it's okay. That one's the one that's lost.
Oh, okay.
Kind of, because it's too small.
The numbers are too small for any optical scanner to pick them up and deposit.
Okay, so maybe I can just take the check back and that will take 2 days.
So how do you suggest that she pays the $1,000?
Whatever way she paid the $1,400, that worked. So how did you make that $1,400 payment?
Well, that was, I believe, the money order, but I spoke with the management there and I told them that it's very hard for me to get to stores.
Here's what you're gonna. I got you. Here's what you're gonna do. Take that $1,000 in any payment that you want, turn it into cash, bring it to the court. We will take it.
Okay.
There's no denominations too small for us to take.
Will you take the checks from my Huntington Bank account?
I can't take a check. I have to have cash. Okay.
Okay.
Well, all right, but that way you don't have to go through the whole money order thing, and then that way it comes in here and I can get it out.
Okay.
Okay. To that. We'll just do it that way.
Okay, just
Very
come with
accommodating, Your Honor.
cash.
Thank you.
Yes, do it with cash. And so, how are you? So, have you applied to Hawk? There's money that's available, but you have to get this account down some.
Yeah, so I'm speaking with someone from support services right now to get it down to 3K because I reached out to the landlord, Calvette, and I asked her, could she work with me on it? And she said if I was able to get it down to 3K, that
Then
she would
you
be,
can.
yeah.
Okay.
I will be able to have $1,500 by the 28th. I wish I could get it faster than, I could, but I
By
only
the
get paid
28th?
bi-weekly.
So nothing before the 21st.
No, because
How much is your monthly rent?
$1,471. I did ask for a one-bedroom unit, but
No,
so I can-
okay. So you've been in contact with the people from Hawk and
Yes.
SOS?
Yes, and they said that
You need to get to 3.
no, they said that I was denied because I made too much money, which I don't.
When did they
think so.
tell you that?
They told me that, let me get to my notes here. They told me that yesterday. They told me that yesterday while I was at work calling them. They said 37 is too much.
But you're not going to be able to have 15 till the end of the month.
Right, but that rolls around with the next month. But if she gives me time to get 3K.
Here's what I'm going to do. I'm going to issue a judgment for possession, finding no tribal issue for the full amount. Ma'am, there's not going to be a writ until the 20 November. Well, court has to be open, so it's December 1st, 2025. So I'm going to give you the whole month. You got to somehow or another get this cleared. You got to deal with them and talk with them. Normally I wouldn't do this in this case, but you've done that. So don't bring, I'm going to do that, but still bring those funds here and then I'll pay it out. So I'm just going to indicate defendant to pay escrow and court will release. So that way we're not going to have where you're trying to pay on this judgment and that whole issue there. Still pay it here and then we'll get it out to them.
Okay.
Okay, but I'm going to give you to the end of the month, try to get this clear.
The full amount.
Yeah.
Okay.
All right, but if you're working with them and get the balance down, I think they'll work with you.
Yeah.
Okay?
Thank you.
Thank you, Your
welcome.
Honor. You have
Thank
a great
you.
weekend. I believe that's call my court.
That is it. Take care. Concrete Place first. Go ahead.
Good afternoon, Judge. May it please the court, Mark Wasbury on behalf of plaintiff.
Your name?
Sigrid Melvin.
All right. I am almost afraid to ask, where are we?
Well, Judge, a couple things. We have scheduled the contractor to do the glazing in the kitchen next Thursday. So by Wednesday, we need everything cleaned out from that area so he can do his work.
Okay.
There's still some items that need to be addressed on the balcony. I don't know what the inside of the apartment looks like. I believe this is her son with her, helping her on those issues.
You're her son?
Yes.
Okay. No, okay, go ahead.
That's it. We want to get
That's
into the glazing. We want to see where we're at on the inside, and we want a couple things addressed on the balcony.
Balcony, okay.
Okay, Monday, I got a call from Mrs. Young.
Mrs. Young,
Yeah,
is she here with us? Yeah, she was here.
I am here. I am here.
Yeah, she
Your
was
Honor.
here the last time,
Yes.
in person.
Yes.
She wouldn't talk to me for the longest time. It was horrible. No, I'm kidding. All right.
I called her back to get an update of what was going on.
Right.
I think you guys went out there Monday after 4. They were gonna take some of her possessions, but in Tupperware. But to put the Tupperware anywhere in the apartment, it would still be in the way. Tuesday, I went out there. Big issue, been taking up the room in the apartment was 3 bookcases of books. With the previous management, we had kind of the same issue because the bookcases were in the hall. They were taking up room going towards the bedroom and the bathroom.
Got it.
At that point, they said it was okay to move them into the living room behind the couch in the building. I went in there, I took out the bookcases, all the books. I had pretty much a pickup truck load of books. She has a lot of old books she's of that. So all that has been moved out. We arranged everything.
Okay.
She has.
Okay, who's this person?
Like with the Housing Bureau for Seniors.
Got it. Okay.
I do have pictures, like, they weren't able to make it inside, but she did a great job.
And anyways, I went out there Tuesday, all that cleared out. Wednesday, when we were rearranged more stuff. When I went out there Tuesday, I did stop in the office and told them what I was doing. And Renee, she was like, just let me know, I need to get pictures. Okay, so I did my thing. Thursday, yesterday, I went out there to the apartment center, went in the office and she was in there. I asked her, have you been up there to get pictures? She said no. So, and at that point, she took me in her office. She gave me some paperwork she wanted my mom to sign to adjourn today's meeting.
This hearing, man.
You know, they weren't on court papers or anything like that, but I'm not declining that. The balcony, we did clear off some of the additional pots that were up there.
Got it.
My point went out there yesterday. I figured we'd go up, take her pictures, and if there was more stuff, more issues, I would know at that time and be able to take care of it. The glazing is really not a problem or an issue. We talked about that yesterday. I'm like, let me know when they're coming. She told me to let her know my counters are cleared up. Basically, anything on the counter or kitchen has to go in.
Let me just stop you there. They're coming on Thursday.
Yes,
Next Thursday.
a week, about six days from today.
Got it. No, they're coming on the 13th.
Yeah, yeah.
All right, they're coming on the 13th. Does she, when you do that, does she listen?
Huh?
What were you gonna say?
I have a piece of paper in my bag where it says, they've been coming August 2024 to do that.
Okay, we're gonna get it. We're doing it now. Okay?
I'll be out there on Wednesday. Get the stuff moved.
And
I have questions about that. As far as reglazing, they're not actually taking the countertops off, they're just re-laminating.
Correct.
Okay. All right.
That's the difference.
Yes, it is. All right. So,
And
go ahead.
then if there's, I know, I was looking at the table and the bench on the patio, and it's like, you know, I told her, it's like, I'll get rid of those and get you a new one for your birthday, you know, but if there's more additional stuff up there, she did come over and take pictures. There is quite a bit of room. Some of the question was access from the door.
Right.
Balcony. Everything around the table is cleared out. The couch is this much far back. So the thing about that table is that's their dining room table.
Got it.
Towards the couch, where she can sit on the couch and eat. On the other side, there's plenty of room, no papers, boxes. If you'd like, you could look at her pictures.
Okay, hang on just one second.
Or if he wants to look at them, see if they're
Yeah.
satisfactory.
Well, and my client would like to, next Thursday, when there's set aside time for the glazing, she would like to go in and look at the inside. That would be a great time to.
I think that would be a great time without disruption.
And then I'm also given a picture it was taken today. This is the balcony.
Well, I can get anything done, yes.
Okay, so I'll just so tell everybody what we're looking at the balcony. There's still off to the left-hand side, there's something hanging. I don't know if those are lights or we're not supposed to have anything hanging.
No,
that's not even a plant.
TV antenna.
That's her TV antenna.
Oh.
I thought we had clarified that.
Well, that's different. Some just to the right of that is a baker's rack and then something hanging.
Oh. Yeah, what are those?
That is, so all the way to the left, it's like a cast iron trellis that the plants to go up.
Right, I see that, but then there's something, if you look up at the top of the balcony, it's like there's a hook there or something, and there's something hanging from that. It looks like it might be lights.
Yeah,
Yeah.
that's the Christmas lights. I haven't taken down yet. But
You haven't gotten them down yet.
yeah,
You told me you were gonna take them down. You'll get them down, right?
well, the hook is very high and I can't reach it. Even
I'll get it.
Okay, but your son's now working with you, so he'll get them down, okay?
Right. No problem. There ain't gonna be no Christmas this year. Christmas lights up and my neighbors, they got the lights up already.
No, don't tell her to. I get everything she's saying, so we just have been determined. Okay.
I heard the last few cases go on and on.
May I have the floor for a minute? When I came here the first time, I bought you a bag with nice stuff.
With the mice stuff.
Right.
Yeah, no, I remember. We made sure that stayed out in the hallway.
And the mice are still in my apartment. I found 2 dead ones yesterday.
Okay, so here's.
Nobody is coming to pick up the mice or change it and clean it up.
Okay, so
It's been
here's.
5 months.
Okay, listen. Here's what we're gonna do. Okay, hold on. Remember, there was the issue, okay, of trying to just get through to get some cleanup in the unit. Okay, but now that process has begun and is happening, then we're going to address the mice issue. Okay? But I want to make sure this first part is done and we get through that. Okay? I promise you.
I've been cleaning the apartment for over 5 months, looking for the mice. When the exterminator comes, he doesn't even bring the tools to catch the mice.
Okay.
And I'm nervous, like, because when I get up, first thing I worry about, am I going to step on it or what?
Ms. Melvin, here's what we're going to do.
Yeah.
I want to get that done. I want to get the balcony in its position because remember, your hanging pot only has about 8 more days left.
Yeah, well, it's the end of the season.
I know, but it's got about 8 more days. I let it stay there till December 15th so that you know that hanging pot has to come down to 15th.
Okay. Oh, what date?
It was the 15th. I gave you to December 15th.
December. Oh.
Yeah. Oh, that's right. No, it's got more time. I did put it in December, didn't I? Oh, no, you got about a month and a half. It could stay there.
Okay.
All right. You're welcome. All right. Pardon?
Countertops are next.
Countertops are next week. Get the light down that's hanging, the lights that are hanging down. Then what I'm going to do is I'm going to adjourn you out a week. Okay? I'm going to adjourn this 1 week. So you'll come back and see me next week. By that point, the glazing will be done. right? The light thing will be down. We'll see what other issues there are left. And then if we have time, we'll talk about the mice, but also the landlord can then look at the unit on Thursday before you guys come in.
They've been coming in and out of the unit without me knowing them or letting them in.
Okay, I presume they have a purpose, but we'll deal with that after we get this first part done. Okay, Ms. Melvin?
Yeah.
Okay, anything else for you?
Yeah, when
Okay.
I went to pay the rent, she wouldn't accept the check. Well, she did accept the check, but then she put it under my door back. And the same thing this time, when I went to pay the rent, and she is my witness that I paid.
It's because of the termination, is that what's happening?
Yes. And my client said she's gone next Friday. She will go in there Thursday, take pictures, give them to me.
Okay.
May I appear by Zoom next week?
If you send in the form, I don't think I'm gonna have a problem with it.
Okay, thank you. Thank you.
All right. Okay, so that's where we're gonna do it. Now, how many months have they not accepted of her rent?
2.
2 months? Okay. Do you still have those 2 months of rent?
Of course.
Okay, so here's what I'm gonna order, because this way, if I order it, it's not a Park Forest issue. You paid the 2 months of rent to them. I'm ordering that the plaintiff accept it. Okay? And that way, that's not a leftover issue that we've got to try to clean up. Fair enough?
Fair enough. Also, my mental and health condition isn't particularly the best, as you can see. I have a blood pressure over 200 every day and 103. So I can't take any more. Just, I've been there since 2006.
Okay, I know. All right, Miss Melvin. Just listen to me. All right. Ever since you've been coming here, you were really worried about that they were somehow going to kick you out and they were going to do whatever, right? And one thing I told you and I promised you is I wasn't going to let that happen unless it's absolutely necessary. And right now, it hasn't happened. So what I want you to do, we're just working through these things.
Okay.
So what I want you to do is just relax. I'm not going to let anything happen until I say so. And if I have to have something happen, I'm going to explain to you exactly why. Because that's what I've been doing, right? When we go through it.
Yeah.
So I don't want you worried about anything like that right now. You hear me?
Yes.
Okay.
Thank you very much, and God bless you.
And the same to you, Miss Melvin. All right. And we'll see you next week. What time? At 2 p.m. Yes, sir. Yes. We'll do 3. They can appear via Zoom. We can do 3 because I appreciate you and everything you've done for your mom.
I know it's at 3 now, but.
All right. Okay, Miss Melvin, take care. Yeah. Right.
Thank you, Your Honor.
Thank you, ma'am. You have a great weekend. David Zawolski versus Lisa Lauro. Casey Zhang. That's so we can get the Zoom information. Oh, okay.
Joe Lloyd, Your Honor, appearing on behalf of the defendant.
Your name, sir?
David Sawalski.
All right. And where are we on this? I have a dismissal.
Oh, there's a dismissal?
I think something was on my door. I just emailed it over to you.
Is the case dismissed?
It was a Zoom for the 27th or something.
But because there were no attorneys, it wasn't signed.
No, I got it. Yeah. You're dismissing this case?
Well, I spoke to our attorney briefly, and I was interested in discussing a settlement that we could work out, but I didn't have much time to talk to him.
I have a dismissal.
We accept, Your Honor. Thank you very much.
Case is dismissed. I'm sorry, Mr. Lloyd, if I had known it was in there, I would have called it.
Well, it's always entertaining, Your Honor. Thank you for your help.
Thank you. Patrick Becker versus Daniel Wolf.
Good afternoon, Your Honor, Patrick Becker. Should be Daniel, Cynthia, and Aaron Wolf.
Yes. Okay. Daniel Wolf, Cynthia Wolf, Aaron Wolf. They are not here. Where are we on this? If you can raise your right hand. Do you solemnly swear affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. What's your claim in this case? How much is owed?
So, Your Honor, if you recall from our last hearing, they have not paid rent in a while and are just not moving out. They made promises in September and then again in October, and then agreed here in court that they'd move out on November 1st. That did not happen.
How much is owing?
Owing is $9,131. That includes back rent and court costs.
$9,131. $31. Okay. Granted judgment to the plaintiff. That's by default. They also appeared, and there was personal service on 1 and 2. And then I think Aaron. So you may get you'll get a money judgment also for that amount of, you said 9,131.
Yes, sir.
$9,131 with a writ to issue in 10 days. So you'll need to go out front, get a judgment, fill it out so that they can present it to me for my signature.
Thank you very much. Does that include an eviction as well?
You have to wait 10 days.
Oh, okay.
That's the writ.
Got it.
Got it?
Fantastic.
Okay.
Thank you very much.
Thank you.
Thank you.